Good morning. Why wouldn't you take that off when the bailiff asked you to earlier?
No, I had told because I had this on. I didn't want to take it off.
I understand, but it's not appropriate and you have to do that and follow the rules. It's not just when you're standing in front of me, but when you walk into the courtroom, there's no head. You should have known better than to wear a bonnet to court in the first place,
Yes, ma'am.
right? This is felony court, not where you show up in a bonnet.
Yes, ma'am.
So why were you late this morning?
I had to bring I woke up late and I had to get my kids to school. So but I had called up here and told them
So how old are you, Miss Richard?
how old am I? 25.
25. So you're old enough to set an alarm and get up on time.
Yes, ma'am.
Okay, so getting up late is some excuse that my kids would have, not something that a grown lady that has her own kids would have.
Yes, ma'am.
You need to be here on time.
Yes, ma'am.
I'm going to recall that bond forfeiture. And let me get to your case real quick. This is your initial appearance in clause number 25, DCCR 1611. You're charged with theft of property with previous convictions from August 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
So what I'm going to do, Miss Richard, is since you made bond, I expect you to at least try to hire a lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone.
Yes, ma'am.
If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, so different payment plans. Bring me the names of the lawyers that you've talked to when you come back, because I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she'll give you a reset notice.
That's Martin. This person is Isis Martin. She was on an issue.
Miss Martin, come up. All right, ma'am, are you Isis Martin?
Yes, ma'am.
And why were you late?
I was waiting on my ride and I had to find my way up here. Just my first time being here.
Say it again.
I was waiting on my ride and I had to find my way up here. I didn't know what's up.
Okay, so it's very important you get here on time next time.
Yes, ma'am.
I'm going to recall the bond forfeiture. And Miss Martin, this is your initial appearance in clause number 25, DCCR 1827. You're charged with a second-degree felony offensive robbery from October 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right, so what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. This one is it this one? Good. You're Robert Felix.
Yes, Martin.
And come on up, ma'am. Let me get this pulled up here. Good. And let's see, this is 21-38610 and 21-38611. Mr. Felix is on probation in each of those cases. One for manufacturing or delivering a controlled substance and the other for felon in possession of a firearm. I received an administrative hearing from Ms. Shoppa Bradley, and in it, the request was to schedule it for a judicial review. So you were in custody and released December 18th. And the stipulation was that you have a GPS monitoring device with 0 tolerance. And it looks like there have been several issues with that monitoring company, that the battery either hasn't been charged properly. Looks like you were out past curfew. January 2nd, on January 3rd. Also. Claim that you have unstable housing. But you're supposed to be giving the information of which of the addresses you're staying at to your probation officer each day. Is that correct?
Yes, ma'am.
So what's going on?
I really don't know what the address I'm staying at. Anytime I was out past curfew was because of work purposes. I was doing dashing. I gave her the receipts of proof for that. I have a job right now, Sparkling Image, looking on my seated
At where?
Sparkling Image Wash Depot, and I also DoorDash. I've been on this monitor for 5 years, Judge. I paid over $14,000 since 2021. And the monitor wasn't really hindering me doing what I need to do. And
Well,
like I make the curfews, I lost my house and everything. That's
well,
why
here's the thing. This was your, hold on. For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming at that angle is not going to go well. Okay. You've had some issues. You were here and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the?
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away of what he needed to take care of. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night, I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge, but I've spot checked, and he's doing it. He's going to school, but this monitor is not acceptable way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I do.
Okay. All right, then. And here's the thing. It sounds like, Mr. Joseph, if you had showed up the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for years. I've been doing it.
You've been coming to, what court you're supposed to come to when it's my date for you to come to court, because you've been coming since you've been on the probation. So that's not, if there's an issue here where you're supposed to be.
I just followed the last directive order. They sent me to Port Arthur.
Who's they?
I had the info.
So here's the thing. Things are going kind of well for you. You probably should quit coming up with excuses. Okay. Because it's probably one of my number one pet peeves. It's just to keep coming up. Just take the personal responsibility. Went to the wrong place. Should have asked a bailiff. You know where the 252nd District Court is. You know the judge you're on probation for. So it sounds like you've got some really positive things going on, and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil, but you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult because if you're changing places, you got to keep telling her. but keep doing all of that. You're gonna be fine, okay? So I'm gonna I will allow the order that the GPS monitoring device be removed. That makes it all the more important though, that you stay in touch and she knows what you're doing, where you are and all of those things.
Yes.
Okay? All right, you're free to go. Thank you, ma'am. Did you just do one or did you do one in each
I
case?
did one and said they were running concurrent.
Okay.
At the bottom was up
Yes, ma'am.
and work.
All right, again, you are Carly Davis. And Ms. Davis, in clause number 25, DCCR 1451, you're charged with the third-degree felony offense of driving while intoxicated. From May 6th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years. And the potential for probation. And then in clause number 25, DCCR 1452, you're also charged with driving while intoxicated, third or more. This one's from February 10th of 2025. Again, if you were found guilty at trial, the range of punishments between 2 years and up to 10 years. And again, the possibility of probation. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer in each of your cases. If you wanted to enter pleas of guilty for 10-year sentences that would be probated for 10 years, there would be the required 30 days in jail. And then there is, well, it's 10 days required. There would order, plea agreement is for 30 days in jail, a 90-day inpatient treatment with a drug patch, and those would run concurrently with a $1,500 fine in each case. Is that your understanding of what the offer is? And you have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
I do.
And do you want to reject that offer and have both of your cases set for trial?
Yes.
All right, we'll get that done. Ms. Davis, I do want to make sure you understand that after today, I will not accept these plea agreements. Once your case is on the trial docket, it either goes to trial, both of them, or if you did change your mind and want to enter a plea of guilty, it would either be open to the court or to some different plea agreements. Do you understand?
Yes, ma'am.
All right, and you've received all the discovery.
Yes, Judge.
All right, we'll get it set for trial. Stay in touch with Ms. DeLage and she'll begin preparation for trial.
Thank you, Judge.
Free to go. Thank you. Mr. Sinclair, in cause number 25, DCCR 0471, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from March 11th March 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management class, as well as complying with any of the rules of CPS. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State Tenors number 1.
No objections, Your Honor.
It's admitted. Is there any evidence that Mr. Sinclair is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing.
Sorry to interrupt, Your Honor. The records, my file indicates this defendant has no criminal history if the court's inclined to waive the PSA.
As long as you're satisfied with the conditions, based on the nature of the offense.
I am.
Okay, then I will waive the pre-sentence report, Mr. Sinclair. Again, find at this time sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney. And at this time, defer all proceedings and place you on probation for 5 years. You're ordered to pay that $1,000 fine and to follow all of those rules and conditions of probation, including complying with any safety plan the CPS has in place, as well as entering and successfully completing an anger management class.
Yes, ma'am.
If you do everything that you are supposed to and follow all of the rules and conditions on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation period, if you have successfully completed it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you could be brought back into court. You could be found guilty, and then you could go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? Also, if you do everything that you're supposed to on this probation, it looks like this is something that's out of character. You don't have any history. I sign early terminations of probation all of the time. So if you get in probation, do everything you're supposed to, then after half or so of your probation, you could potentially get off early. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right over there. She'll call you up when she's ready to go over your paperwork.
Okay.
Thank you. Good luck to you, sir. Thank you, Ms. Simmons. And Mr. Clark.
Yes, Judge.